Quince.
Hello, good to see you.
Thank you very much for agreeing to sit with us and participate in this project for the Florida Supreme Court Historical Society.
Okay.
What we're going to do today is talk a little bit about your experiences, the experiences of the court in connection with the 2012 merit retention election.
Okay.
Let's provide a little bit of context, a little bit of background for those who might view this interview. When did you join the court?
In 1999, and January of 1999.
For us, so that viewers understand the purpose of the merit retention system and how it functions.
Well, the merit retention cannot talk about it out of context. You have to talk about merit selection and retention. Now, merit selection is that process where when there are openings on either our appellate courts or the Florida Supreme Court, persons who feel that they are qualified to be on those courts apply to our judicial nominating commission. Names are vetted, interviews take place, and then names are sent to the governor for appointment to those courts. So that's the merit selection portion of it. Once you are appointed to either the appellate court or the Florida Supreme Court, you have to stand for merit retention. Merit retention takes place the first year after you've been in the first general election year after you have been in office for at least a year. So I was appointed to the Florida Supreme Court in 1999 and actually stood for my first retention in 2000.
Stood for retention.
I have been on the retention ballot 3 times, 2000, 2006, and 2012. Now, I was once on the retention ballot when I was on the Second District Court of Appeal. So actually, this is the 2012 was my 4th retention.
Where does it find its roots? Is it in the Florida Constitution? Is it by statute? How does it arise?
It really, the merit selection and retention system arise from the Constitution. You have to go back a little ways to realize that prior to the 1970s, we had election of our Supreme Court justices. Then in the 70s, there was really a big scandal about concerning, I believe, at least 4 members of the Florida Supreme Court. And then Governor Ruben Askew asked the legislature and the people of the state of Florida to change our method of selection. Rather than having general open elections, that's when we went to the merit selection and retention system.
In any of the prior instances where you have gone through the retention process, had you drawn organized opposition?
Not really. In 2006, there was a little activity on the internet, but it was not such that I would have called it organized opposition. In little pockets here and there, there would be, I wouldn't say ads, but there would be some information on the internet telling voters in particular counties who had appointed the people who were up for retention. But that was very minor, so I would not have called it organized opposition.
Had you ever, prior to 2012, ever considered in any of those retention elections what efforts you might have to undertake to retain your position?
I never really gave it a lot of thought. The first retention, when I was on the second district, you simply send in to the elections office that you want to be on the ballot, and that was the end of it. The 2000 for this court, it was the same thing. In 2006, we sent in our information, told the supervisor of elections office, I assumed, that we wanted to be on the ballot, and that was basically the end of it. It was only in 2010 that we really got any inkling that retention elections may not look the same as they had looked in the past.
To consist of candidates who are free to say just about anything they want to say in an effort to get elected. Now, as lawyers, we know that's not the case in the judicial setting. What limitations or restrictions are in place regarding what justices can say or do in connection with the merit retention process?
Well, first of all, you have to understand that when you are talking about judges and justices, that we have to come to every case, every situation with an open mind, with no predetermined position. And so that puts a limitation on what you can say and even do in any kind of campaign. You cannot have prejudged any issue. Often you get questions about, what do you feel about abortion? How do you feel about this issue? How do you feel about that issue? I can't say that I feel any way about an issue until I have seen the facts and the law that is applicable to that issue. And so that, in and of itself, puts a limitation on what you can say in a campaign.
A certain degree of frustration with those limitations when you are in the electoral or the retention process?
I really don't feel that it's a limitation, the fact that you can't talk about certain issues, because I truly believe that in order to handle someone's case, in order to be fair and impartial, you cannot prejudge any particular issue. And so I don't really see it as any real limitation.
I think you indicated in an earlier response that around 2010 you began getting the sense that retention elections were no longer going to look the same. How did that impression come about?
Well, it came about because in 2010 we had 4 people from the Florida Supreme Court on the retention ballot. 2 of those persons, there was a minor organized opposition against 2 of the persons who were on the 2010 ballot. And actually, the numbers for those 2 persons, that is their retention percentages, were lower than we would normally have expected. And so it gave us some indication that even this minor organized opposition maybe had some effect. And then, of course, after the actual election, one of the persons who had been involved in that opposition actually said in a newspaper article that he was going to he and his organization would be opposed to the 2012 retention persons.
Justice Perry has publicly stated, in connection with his most recent retention election, that he felt, and I think I'm quoting here, like a sitting duck. Did you feel the same way?
I guess to a limited extent, I think retention elections, you probably do feel somewhat of a sitting duck, because there are limitations on what you can do. There are limitations on what you can say. There are limitations on fundraising. And so you do, and you don't have any specific person that you are opposing. It's more I'm not even sure how you term it. Ideology, maybe? And so it does make you somewhat uncomfortable.
Process and seeing that there might be organized opposition to your retention in 2012. Did you reflect at all upon the successful ouster of 3 Iowa Supreme Court justices who had voted on a decision involving same-sex marriage, upholding same-sex marriage in Iowa? Did that ever cross your mind?
I certainly thought about the Iowa retention election where 3 persons were ousted. In fact, I listened to one of those justices, Justice Baker, speak about what had gone on in Iowa. And one of the things that really struck me about Iowa is that the 3 justices did not wage any type of campaign for themselves. And I thought about that very seriously because it just did not seem appropriate to me that one side got to say whatever it is they wanted to say, and there was nothing in opposition to that.
Ever consider at any point in the greatest heat of the 2012 retention process, did you ever consider walking away from the position and saying it's just not worth this?
I never did, because I felt that I had been doing what I have been selected to do, and that is represent the people of the state of Florida, and that I was a fair and impartial justice, which is what the people want. And so I did not feel that this campaign was really a truly legitimate campaign. And I, quite frankly, refused to allow that kind of propaganda even to go unchallenged.
Any memories of the campaign to unseat Justice Leander Shaw Jr. back in 1990?
It certainly did, because as I understand what was going on with his campaign, it was about the way he had voted on several cases. And that's what Justice Shaw, I believe, was being targeted because of his votes on several cases in the 1990s. In 2012, we were being targeted because of our vote on several cases. And so it certainly reminded me of what went on when Justice Shaw was targeted.
Campaign, and I think it's probably fair to say that there wasn't quite the level of active opposition to the naysayers, let's say, as there was in 2012. Given that he succeeded in retaining his seat, did you have reason to believe that the political atmosphere was any different this time around?
Well, Justice Shaw had his opposition at a time before the internet and many of the social outlets that we have now. And so it was really more of a typical kind of campaign. Whereas in 2012, even 2010, you get a lot of information. People get a lot of their information from social media, from television, and so you had to look at it from a different angle than you would have in the 1990s.
We've perhaps reached a tipping point with these efforts where we can no longer have confidence in the system we have?
Well, I tell you that I don't believe that we should go backwards. The election of our high court justices and our appellate court judges, I think, would be a real step backwards. We saw what could happen when people are elected and feeling beholden to people who have given them campaign contributions. We have only to look at the Caperton case out of West Virginia, where the justices there are elected in contested elections, and all the big money that flowed into that campaign. So I think electing our judges and justices would be a step backwards. Is there something that can be done about our retention system? I certainly think there might be ways to improve on it. I think the federal system where judges are appointed for life might be a good system, or even a more lengthy period. We have 6 years and you have to be on the election ballot. Maybe we should have 12 years or 15 years or some other period of time. There are ways you can improve on the system, but I do think that the retention system is much better than the elected system.
Oppose your retention and that of, it wasn't limited just to advertising, was it? I mean, there was an FDLE investigation that was conducted, and even a lawsuit was filed. Can you tell us a little bit about that?
The FDLE investigation, which was called for by the governor, had to do with who notarized our papers. Now, every year we file financial disclosure statements as a state elected official. We usually have those notarized by anyone in this building who's a notary. We did the same thing with the papers that we filed for our retention. You have to file to indicate that you are going to be on the retention ballot. Otherwise, your seat becomes open and the governor gets to, make a new appointment. So we had our papers notarized in the ordinary course. And someone took issue with it because the person who notarized it was a state employee. Now, it seems very ironic. If I had not had it notarized in this building and I had gone over to the supervisor of elections office, or the person, I believe it's the supervisor of elections office where you file your papers, I could have gotten it notarized there. That person would have been a state employee. So an investigation was called as to whether or not that was a criminal offense to have your papers notarized by a state employee. And the FDLE investigation says no. It was turned over to the state attorney's office. The state attorney said no. Yet still, out-of-state people filed a lawsuit saying we should not be on the ballot because of that notary situation.
At one point, the state Republican Party openly voted to oppose your retention, didn't it?
Yes, the Republican Party, the state Republican Party, voted to oppose the retention of the 3 justices who were up for retention.
Had that ever happened before with the state political machinery for either party, Democrat or Republican, had become actively involved in the merit retention campaign?
To my knowledge, no political party has ever weighed in on a retention election prior to 2012. And in fact, there is a statute, I believe, that indicates that political parties are not to get involved in retention elections.
Did any politicians raise this issue with you privately?
I never talked to any politicians about the issue. I did talk to many Republicans who were very upset that the party had in fact gotten involved in a nonpartisan retention election.
This subject, but do you think there's any role, whether actual or theoretical, for a political party on either side to have involvement in a judicial merit retention election?
I really don't, because it is a nonpartisan issue. The retention, even the selection, is supposed to be a nonpartisan issue, and therefore I don't believe that political parties should get involved in it. The court is there to resolve disputes and not to take positions on issues, and that's what political parties are all about. That's what our other two branches of government is about. Just as I cannot get involved in any kind of election process with the legislature or the executive branch, I don't believe that political parties should get involved in retention activities.
Obviously, at some point, members of the bar around the state of Florida became involved in waging a counter campaign. How did that first come about?
Well, first of all, I would not call that the bar's involvement in the retention campaign as a counter campaign. I believe they did an excellent job as an educational campaign because many people really have no idea about merit selection or merit retention. Most voters, if you ask them, would have no idea often of who is even on the Supreme Court. They certainly have no idea of whether the people are doing a good job or not. They have no idea of what they should be even looking for when they are voting. And so I believe that the Florida Bar actually did a good educational campaign to make people more aware of the merit selection and retention system.
Was this educational campaign centralized in any way or coordinated in any particular fashion, or was it just
I think you would.
well-intentioned lawyers around the state who wanted to help?
Well, it certainly came from the bar itself. So I think you would. A good person to talk to might be Jack Harkness, who is the executive director of the Florida Bar, or even Gwen Young, who was the president of the Florida Bar at that time, because certainly it was at the Florida Bar level, but members of the Florida Bar actually took the message out to the public.
Were you actively involved in any way with this educational campaign?
I didn't actually do their educational campaign. I did my own educational campaign. We were asked to speak often at different places, and so I would try to educate people about how we got to the merit selection and retention system, go back to the history of what had happened in the 70s that made this change come about, and explain to them the dangers of, electing our higher court judges. I often spoke about the West Virginia case that I talked about. I told them about what had happened in Iowa. And even in some other places, because as you well know, in Tennessee, some years ago, a justice was not retained because of votes about the death penalty. Different cases like that. I tried to make people aware of the dangers of looking at just one case or even a series of cases that any person may have voted on.
Well, how did these educational efforts on your part, affect your ability to handle what must be a significant number of duties that you have here in the court?
Well, of course, I had to spend a lot of extra hours doing both the work here and trying to wage a campaign. But quite frankly, I must tell you that because of technology, you can do a lot of things now remotely that you certainly could not have done before we got to the stage of iPads and all of these, yes, all of the other devices that we have. And so it's much easier now to actually be out of the office, but be in the office.
To unseat concludes the educational campaign, concludes the election comes in. Were you surprised by the results?
Well, I wasn't exactly surprised because to tell you the truth, I felt that the campaign was going really well. I felt that the bar's educational campaign was making a difference. And I think the opposition has sort of run out of steam. So I was not really surprised, but I was very glad to see it. It really made me think that the public truly understood the message that we were trying to give them.
The percentages have been 70 some odd percent retaining 20. You always have that 25% or so.
Or even 30%.
Yeah, even 30% who just are unhappy with whoever's in office
Mm-hmm.
and want to take them out. So the difference in percentages was not huge.
It was not, in my estimation, the difference in percentages was not even significant. Because there have been retentions where the rate was 67, 68%, 70. I mean, the range has always been somewhere between 65 and 70%. So I did not think of this one as outside the norm. And I was very happy to see that.
Was that the result of a successful educational campaign or a simple inability by any side to reach the Florida electorate on issues having to do with judicial retention?
Well, I think it really was a successful educational campaign, because prior to the election, maybe a year before, there really was some polling done. And the numbers did not look good. And people were not aware. And so, and when you have someone who's out there saying don't retain, if you do nothing, you get what happened in 2010. You get what happened in Iowa. And so there are people that you have to educate, I believe, about merit retention if you want to continue to have the kind of numbers that we got.
Do you think going forward we now have to have this kind of educational campaign every time?
Well, you might. I would hope that the people who mounted this opposition will realize and maybe learn something from the educational campaign too, that this is not what merit retention is all about. It is not about one or two cases that you disagree with. It is about whether or not judges are fair and impartial. It is whether or not they are the kind of people that you want to retain in office, that these are not the kind of people that you hear scandals about or anything like that. That's what merit retention is about keeping, I believe, people who are fair and impartial. And none of us are going to agree on every case. So that cannot be the question that you ask yourself when you are voting to retain or not retain.
That harm has been done to the process anyway?
I think harm has been done only to the extent that that the public hears things that are not necessarily true. I mean, for example, one of the issues that was raised in this campaign was whether or not we were going to let someone who had committed a murder go free. Well, that was never really the issue, but that's the kind of thing that really makes the public want to sit up and take notice. The issue was whether or not the person had had an effective assistance of counsel, and if not, was he entitled to a new trial? Not whether or not he was going to be let free, but it was turned around into letting someone off who had committed a murder. And those are the kinds of things that I think do just an injustice to the system because of misinformation.
in hindsight, what would be in a merit retention scenario?
I think that merit selection, merit retention is the equivalent of what we have in the federal system, that you hold office during good behavior. And if a justice or a judge is not in good behavior, then I think that's what you oppose them for, not because of any one or two opinions. Because I would imagine if you took the same people and asked them about some other case that I had voted on or authored, they'd think it was a wonderful opinion. So it can't be nitpicking one or two opinions that you disagree with. It has to be character and fitness to hold office.
If anything can be done to avoid the disruptive effect and expense of these campaigns in the future?
What can be done to avoid these kind of campaigns in the future? I'm not sure that I can answer that question, because I cannot, and I don't think you can stop any group or person from doing exactly what was done in 2012. You can't really stop people from doing it, even though I believe that that's not the appropriate, that what they were doing was not appropriate because it was based on one or two cases. So, but I'm not sure how you stop people from doing that. I think you have to continue. The only thing we can do, truly, is to continue to educate people about the process and continue to explain to people the purpose of the judiciary. A lot of people have no idea. So we have to continue to educate.
Okay. What, if anything, can be done in the future, Justice Quince, to avoid the disruptive effect and the expense of these kinds of opposition campaigns?
I wish I had a good answer to that. I wish I knew what could be done to avoid these kind of campaigns in the future. But I'm not sure what we could do, and I'm certainly going to try to give it some more thought and see if there are some things we can do to change our retention system. But anyone can at any time oppose a judge or justice who's up for retention, and we can't change that portion of it. But I think the best thing we can do is to continue to educate the public about our judicial system, to educate the public about the purpose of the judicial system, why we need a fair and impartial judicial system. Because quite frankly, these kinds of oppositions are, I believe, a part of it is to intimidate judges into ruling the way these groups would like judges and justices to rule. We can't have that. We have to continue to have judges who are fair and impartial and are making decisions about cases, not on any political whim, not on even popular opinion, but on the facts, the statutes, and the Constitution.